Thank you all very much for joining our webinar today on Unwired Planet versus Huawei, Supreme Court decision from the United Kingdom regarding standard essential patents and France. We have the great pleasure today of welcoming Rory, Clarke and Stephen Baldwin from Kirkland and Ellies from the London office, two extremely sharp minds who are quite intensely working on standard essential patents to offer an overview and insights of the key aspects of this case, which has occupied quite a few people in the UK for quite some time. For those who don't know Oxford is a spin-out from Oxford University. We have been up now for 10 years and we specialize on economic aspects of intellectual property and competition law. And we have a strong interest in the valuation of IP, which we apply to help companies attract funding, to launch new startups, to attract the attention of venture capitalists. But we use our skills also in licensing negotiations or in arbitrations or in legal proceedings, and we offer also economic insights for public policy formulation. We are running this webinar series as part of a larger conference that we will also be holding again next year, either online or real, on standards and patents. We're planning to run the 6th IP and competition forum sometime in springtime, COVID permitting. So I would now like to give the floor to Rory and Steve, who have prepared a really, really nice PowerPoint presentation, and make them the speakers, if I understand how the software properly works. Bear with me for a second. No, Rory, maybe I can already. Okay, participants, Rory. Okay, I'm unmuting you now. And more, I'm making you the host. Okay, so we'll see now your screen, Rory. Just that you know. But I should also like to say this meeting is under Chatham House rules. So Steve and Rory would not be too happy if you quoted them one-on-one. That wouldn't be commensurate with Chatham House rules. Rory, you are, I'm stopping now. Yeah, exactly. We're seeing now your screen and the PowerPoint presentation and the title Unwired Planet versus Huawei and Conversant versus Huawei and ZTE. I'm going on mute. If you have questions after the talk, please fill them in that little box so we can react and reply to them. Thank you.
Hi, Rory. Just before you go across, have you got Steve on as well?
Nope. I thought you're using the same access code. Oh, here he is. Sorry about that. Dear. You know what? While I'm figuring out my software adventures, maybe you can already get started so that we don't lose too much time. I don't know how to make this now change.
Sure, no worries at all. So starting off then on the presentation for today and giving a bit of an overview of what will happen. But while Roy's doing that, I'll introduce myself, and my name's Rory Clarke, and I'm one of the associates in the IP litigation team at Kirkland and Ellies in London. And I'll be co-presenting today with one of the partners that I work with, Stephen Baldwin. Our kind of background and interest in this matter is that we're actively involved in patent and in particular SEP and mobile telecoms litigation. And so this is one of the cases that obviously we've been following with quite keen interest. And so we're delighted to be here today to have an opportunity to talk to you about what happened in this case and some of our thoughts on where it might go next. Looking at that then and the structure of how we want to run the talk today, I'll begin by going into the background of what happened in this litigation and how it ended up in the Supreme Court in the UK. We'll then move on to look at some of the key points from the decision itself, and that'll be split between myself and Steve. And you'll see that the decision was split into 5 key areas or issues, and so we'll split those between us. We'll then move into the discussion phase where we'll pick on a couple of the themes that came through from the judgment. Hi, Roy.
Yeah, Rory, I can only make Steve also a presenter if I change and become again the host.
Okay, that's fine. So what I'll do is I'll just finish the overview and then I'll let
Roy the host back and forth again. Okay.
So we'll then wrap up with a piece of discussion where we'll pick a couple of the themes that we've drawn from the judgment itself, give some initial thoughts as to where we see these areas may develop or potentially could develop. And at that point, we'll sort of invite any questions or comments from the audience members and see if we can take the discussion on that. Overall, we expect the talk will run for about 45 minutes or so, and then time for discussion at the end of that. So I'll pass back to you, Roya.
I think only one, either you or Stephen are the chair, but not both of you together. So what I'll do is I'll keep on chairing the meeting, and you tell me when to turn the slides so that I can have you both speak and see and everything. Okay?
Yeah, that sounds great, Roya. Thank you.
Okay. Oh, is it? Go ahead. Okay. No, we seem to be still seeing your screen. Apologies for that delay. Yeah, we're still seeing your screen. And Stephen, you seem to be live now too. You. We're getting it. People don't think we didn't rehearse it. It's just when you go live, there's always a last minute emergency nobody expected. Go ahead.
Great, thank you, Roya. So as I said, we'll move into the background and what happened in this dispute. So as a lot of the audience will be aware, in late August of this year, the Supreme Court handed down its decision in the co-joined appeals of Unwired Planet and Conversant. This is one of those matters where, although it nominally 2 sets of cases concerning patent infringements, has significant ramifications for the mobile telecoms industry, and in particular in terms of standard essential patent litigation and FRAND obligations that were associated with them. In particular, the UK so far has been the only jurisdiction to effectively say that it was willing to settle the terms of a global FRAND license, irrespective of whether parties to the litigation were willing to actively consent to being subject to the UK court's jurisdiction. And so this decision was quite highly anticipated as to whether the Supreme Court would confirm the UK court did indeed have that jurisdiction. As I said, it was long awaited as the case was heard, or the appeal itself was heard back in October of last year, and the decision was handed down almost a year later in August. Looking at the background to the 2 cases then that found their way up to the Supreme Court, we'll start with Unwired Planet and Huawei, which is effectively the case that set the tone for the UK having this jurisdiction to determine global FRAND licensing. In terms of looking at the action itself, it was brought by Unwired Planet, which is a non-practicing entity, and it sued a number of mobile telecoms implementers, including Huawei, for infringement of a number of patents within a global SEP portfolio. So in terms of the portfolio it was suing upon, it was an ex-Ericsson portfolio, which was of quite significant size and span. And so the portfolio itself covered approximately 42 countries, and there were approximately 280 patent families or applications that were declared as standard essential patents within this portfolio. Of those, there were 29 UK patents and 5 had been asserted in this action. In terms of the first instance proceedings then, these took place in 2015 and 2016. And there were a number of technical trials at the beginning to determine the validity, essentiality, and infringement of the patents in suit. During those proceedings, only 4 of the patents were actually tested, with the proceedings for the 5th patent stayed indefinitely. During that, it was found that 2 of the 5 patents were valid and essential, which gave a gateway on to moving to the FRAND or non-technical trial to work out what the remedies would be for this patent infringement. So the FRAND trial itself took place in late 2016, and then the judgment was first handed down in April of 2017. The key points from the decision in Unwired Planet at first instance were that the undertaking, or the ZTE undertaking, to license the standard essential patents on FRAND terms was something that was justiciable and enforceable by the English court. It was then also quite notable that the creation of what's become known as the FRAND injunction appeared from this matter, as the court effectively determined royalty rate and license for what it considered to be FRAND in this instance, and issued a conditional injunction. The condition being that the injunction would only bite if the implementer did not accept the license on the terms the court had settled. The notable feature as well from this was that it was a global license, and the court found that the appropriate FRAND license in this case would be global. We then move to the second piece of primary litigation, which is Conversant and Huawei and ZTE. Again, Conversant is another non-practicing entity, which also had a very large global portfolio. The span of Conversant's portfolio was approximately 40 countries. And again, in its portfolio, it was huge in size, with 2,000 patents or applications, which was said to be standard essential. Looking at where the portfolio came from, again, this was another sort of derived portfolio, this time coming from Nokia, and it had been acquired by Conversant back in 2011. During the proceedings, Huawei and ZTE made an application effectively challenging the jurisdiction of the English court to determine this matter. And as you can see on the screen, there were 2 bases that they sort of made this application. The first was that this matter involved a determination of the validity of foreign patents, and so the English court did not have jurisdiction to do this. And then secondly, it was on the basis that irrespective of whether the English court had jurisdiction, it was not the appropriate forum to be trying this case. Both of these applications were dismissed, with the trial judge finding that the English court did have jurisdiction and that there was no reason that it wasn't the appropriate forum. Both of these cases then, so Unwired Planet and Conversant, were appealed to the Court of Appeal. And in short, this can be taken in quite short order, which is effectively the Court of Appeal held up or upheld both first instance decisions. One notable point that came out of the Court of Appeal's decision was in relation to Unwired Planet, where in a deviation from the first instance judge, it found that it was possible for there to be multiple rates or multiple licenses which were FRAND, as opposed to a first instance where it was found that only a single license or rate could be FRAND. However, although there could be multiple rates, this was something that didn't affect the underlying reasoning of the judge at first instance, and effectively it was a choice on the SEP holder as to which FRAND license it sought to take. Both of these decisions were then appealed up to the Supreme Court, And this is the appeal that we'll be talking about in a bit more detail today. Looking at what happened at the appeal then, it took place, as I said earlier, in late October and was before the full Supreme Court, or a full panel of 5 justices of the Supreme Court. Looking at the points they considered on there were 5 main issues that were before them. Point 1 that's up on the screen is effectively, did the English court have the jurisdiction that the Court of Appeal and the first instance judges had found it did have to be determining global friend licenses? The second issue then was, if the English court did have this jurisdiction, was it the appropriate forum in these specific cases to be determining the claims that were before it? There was a specific point then about the issue of the non-discrimination component of the FRAND obligation. And effectively the question here was, is this a hard-edged obligation or not? And was there any obligation for a SEP holder to be offering the best terms it had offered to a different licensee to these particular licensees? We then look at points 4 and 5, which concern, or looking more towards the CJU's decision in Huawei and ZTE. The first point, and point 4, was, had Unwired Planet acted abusively in seeking injunctive relief in the manner it had? And then the next one was related to this litigation, and it was whether a SEP owner is actually entitled to seek injunctive relief at all, or whether damages would be an adequate remedy, given the FRAND obligation and the undertakings that have been given to Etsy. So with that, we're going to move on to a discussion on some of the key points from the decision, and I'll pass over to Steve at this point.
Thanks, Rory. So yeah, as Rory said, he's gone through each of those 5 issues. So I thought it would just be useful to go through some of them in a bit more detail, taking each of the issues in turn. In terms of the overall assessment, and I'm sure most, if not all of you listening to this will be, will be aware that, effectively the SEP holders won on effectively every point, and it was a unanimous decision of the Supreme Court, such that ultimately the appeals were effectively dismissed on each of the points. I think it's fair to say that one of the only points from Mr. Justice Burse's decision in Unwired Planet that didn't stand was the idea that there is only one single FRAND rate. The UK Court of Appeal disagreed with that and held that FRAND was a range. But other than that, the decision of Mr. Justice Burse, largely speaking, was upheld by the UK Supreme Court, who, as Mr. Justice Burse himself has noted a few times, has referred to his judgment as an impressive judgment. So I think it's fair to say that it was a substantial victory in this case for the relevant SEP holders. In the next slide, please, Rory. So in terms of the jurisdiction issue, and Rory's mentioned this already, but really the 2 key areas that they were looking at: do they have jurisdiction to grant what they call these FRAND injunctions? So an injunction unless the implementer takes a global license, and then additionally, did they have jurisdiction to determine the royalty rates of the license in question? And I think that the key thing that's come out of the Supreme Court judgment from this perspective is that they really grounded jurisdiction on the Etsy contractual undertaking. So from the Supreme Court's perspective, it was really looking at the IPR policy, looking at that irrevocable undertaking that's given as a matter of contract. And it was the view of the Supreme Court in that scenario that because it was a matter of contract, rather than a matter of national patent law, then it was something that they were able to do, and they could determine these global license terms. I don't actually think that this was, for some people in the UK, that surprising an assessment to come out of the Supreme Court. The Supreme Court justices that heard this case, they're not IP specialists. A lot of them have got a commercial background, and it's very, very common in the UK for there to be English law contracts where you have an English law contract, but you have 2 counterparties from various parts of the world. And in the commercial courts, and a lot of the background these trustees have as commercial lawyers, it's not particularly unusual for them to be dealing with a situation where there are non-UK parties who are dealing with a contract and are asking the UK court to determine the terms of that contract. So it's not altogether surprising, I think, that the Supreme Court alighted in particular on the ETSI contractual license. Let's move to the next slide, please, Rory. So we've mentioned a number of times the idea of the jurisdiction to grant an injunction, or what we've been referring to as a FRAND injunction. And in doing so, the Supreme Court rejected the argument that Huawei made that ultimately the ETSI IPR contract prohibits the SEP owner from seeking an injunction from national courts. And embedded within that, and I'll come to it later on in the decision, was the notion of country by country licensing. And any idea of making this a national assessment whereby the SEP holder may have to go country by country was just seen by the Supreme Court as impractical and something that they weren't willing to endorse. And this was sort of built into this idea of them being able to grant the FRAND injunction. But interestingly, when you sort of read the initial background of the judgment, there's a lot in there where the Supreme Court talks about what they refer to as the balance, or in fact the fair balance that they refer to, that they say underpins the IPR policy. And really the way that they seem to see it is that the IPR policy gives implementers a choice. Either they take the license, or alternatively they take the injunction. And just pausing on that choice of the implementer there. I mean, one thing that we've seen in the UK already in the TQ Delta and Zyxel litigation is a situation where in that case the implementer decided that it would rather, for various reasons factually specific to that case, it would rather take the injunction instead of taking the relevant FRAND license. And so I think in this particular aspect of the Supreme Court's decision, they appear to be endorsing that general view that the implementer ultimately could take the UK injunction if it chose to do so. And it's been interesting. We also saw, for example, HTC pull out of the UK market following its patent dispute in the UK with IPCOM. I mean, I think in practice it remains to be seen how practical this is for any implementer of any size with any real size of market in the UK just to pull out. I mean, I think that remains to be seen. But it's interesting that the Supreme Court alighted on this particular choice. Like, you either take the license or you take the injunction. And one of the things I think underpinning that, and again underpinning the general decision of the Supreme Court here, was the idea of providing what they refer to in the judgment as a strong incentive for implementers to negotiate and accept FRAND terms. And we've seen, separately from the Supreme Court decision, we've seen UK judges, for example, Mr. Justice Burst, talk about the fact that he was effectively filling a void where he felt that there was nothing in place to effectively give the implementers this incentive to enter into licenses. And so again, this is the Supreme Court sort of suggesting that there needs to be something to prevent what they see as holdout from implementers. I think when they're looking at hold up, they appear to be less concerned by the notion of hold up. And my interpretation of that is that the way that they see it is ultimately, if you're doing a FRAND determination in the UK court will determine what terms are FRAND. So ultimately, the amount that is paid to the SEP holder will be a FRAND amount as determined by the courts. And so in that scenario, it is more important to prevent any kind of holdout or any kind of delay on the side of the implementer. The next slide, please, Rory. So in terms of just connected with what I was just talking about, the other aspect of jurisdiction is this jurisdiction to determine the rates. Okay, you can grant the injunction, but how do we go about actually determining the royalty rates of the underlying global license? I've mentioned already that they grounded that jurisdiction primarily in the ETSI contract. And even if the portfolio contains foreign patents, it really wasn't a concern to them at all that the portfolio might contain foreign patents. They adopted the High Court and Court of Appeal view of life, which is that this is a case about UK patent infringement. It's a UK injunction for the UK market. And so, ultimately, we're not determining questions related to the validity and infringement of foreign patents. But in the course of this discussion in the judgment, you see around sort of paragraph 60 to 65, they talk about the fact that implementers can, in principle, reserve the right to challenge patents within the portfolio if, for example, they consider them to be weak or a selection of them to be weak, and build in an adjustment mechanism for royalties that effectively can take account of the results in those foreign jurisdictions where, for example, the implementer may have decided to challenge the validity and/or infringement of some of those patents in foreign courts. And they also mentioned the possibility, they left it open, but they mentioned the possibility of there being some kind of clawback mechanism and a license such that, you know, if a decision comes out in a foreign country and there is for example, you know, a number of patents are invalidated or found to be not infringed, then if the royalty rate in the license is adjusted accordingly, there should potentially be some kind of, you know, clawback mechanism which enables the implementer to effectively claw back amounts that may have been overpaid under the license prior to those foreign decisions coming out. Next slide, please, Rory. So just finally then, I think this is an important point, and it goes right through all of the reasoning of the lower courts through the Court of Appeal to the Supreme Court, is that, you know, the UK courts really see their decision in this case as a reflection of commercial practice, what people in the real world do. People in the real world, in their view, enter into global licenses. I think often, in terms of the evidence that comes out in the UK cases by virtue of disclosure, I think they often took quite a lot of comfort from the fact that the license is disclosed in the UK litigation, where often, if not always, for global licenses. So they really just feel like they're mirroring what is the commercial practice of you know, of both implementers and step holders in the industry. Huawei had made a point repeatedly in the Court of Appeal and the Supreme Court, saying, well, look, you know, it's one thing if you want to look at the jurisprudence in, for example, China, or you want to look, for example, in the US, because in cases, for example, in the US where there has been a global fund determination, it's been done by consent. And there is a distinction between a situation where a company enters into a contract voluntarily and a court effectively imposing a global license on an implementer. But the Supreme Court wasn't convinced by that argument. Their view effectively was that, you know, because what we're talking about here is a contract, actually there is no compulsion, because there remains the option for the implementer to not take the license and to take the injunction if they choose. So their view is that they are not compelling the implementer to take the license, and they therefore effectively rejected Huawei's distinction in terms of a situation where both sides are agreed that a global fund determination should take place, versus you know, the situation where, for example, the step holder files a case in the UK but the implementer does not consent. And ultimately, yeah, the Supreme Court keeps coming back to this point. You know, their view is that the IPR policy made by ETSI effectively envisages that courts may decide whether or not you know, the terms of an offered license are friend. So they see the ETSI policy as international, they see the obligations they're under as international, and it's therefore their view that you know, courts can decide on whether or not the terms of an offered license are friend, and if that license is global, then the UK court is in a position where it can do it. Next slide, please, Rory. So moving on then from the jurisdiction issue to the question of suitable forum, or as UK lawyers often refer to it, forum non-conveniens. The key point here is that you had Huawei and ZTE arguing that the UK court was not the suitable or convenient forum for this dispute, and instead that the most suitable or convenient forum was China. And effectively, this argument fell at what the Supreme Court referred to as the first hurdle. And ultimately, the reason this failed is because from a UK perspective, if you are going to succeed on a forum convenience argument, what you need to show is that the jurisdiction you're saying is most suitable will in fact do what you're suggesting it will. So what the evidence in this case was surrounding was whether or not the Chinese court would in fact conduct a global fund assessment. And as you can see there from the highlighted wording, ultimately the English court decided on the evidence before it that at least for the time being, the Chinese courts have not stated that they will determine a global FRAND rate. And in fact, on the evidence before the court, that was with or without the parties' agreement. It wasn't clear, even if the parties consented, whether or not the Chinese court would do that. By contrast, of course, as I've just explained, the English court considers it does have jurisdiction to make these determinations. And so on that basis, it was a comparison between the English court, which did have jurisdiction, and then another jurisdiction which did not. So in that circumstance where the Chinese court would not be willing to do the same assessment, it could not be considered to be the suitable forum. So effectively, the argument failed at the first hurdle. Next slide, please, Rory. But in making that decision and effectively saying that the argument fell at the first hurdle, I think what's interesting about this judgment, and it's one of the points we'll come on to discuss later in context of the discussion, is that ultimately this was limited to the evidence that was before the Supreme Court at the time. And in the judgment, they make it very clear that they're saying that they use the words at present. So they say at present, the Chinese courts will not do this. But they also make it very clear when you're reading the judgment that they consider that it is completely open to other fora outside the UK to also do these global FRAND determinations. And the reason why the Supreme Court says that is, as I've explained, they interpret jurisdiction as a matter of contract, as a matter of the ETSI contract, and as far as they're concerned, if they, as the English court, are able to do this, then other courts, provided they say they're willing to, can also carry out these global FRAND assessments. And as part of this forum non-convenience discussion, there are a whole raft of very, very complex jurisdictional law points which were being run by Huawei. But because they failed at the first hurdle, because on the basis that China would not do the global FRAND assessment, the Supreme Court basically said, right, we're going to park all of these points that Huawei are running, but if and when other countries decide to exercise jurisdiction to settle global licenses, and somebody raises the forum non-convenience point before us again, then in that circumstance, we will consider those arguments and take it into account. So, you know, if you have a situation where whomever it might be, the US courts, the French courts, the German courts, the Chinese courts decide that they're going to determine global FRAND, there may be forum non-convenience based arguments that can be run again, particularly outside of the European Union in the US and in China. And next slide, please, Rory. So I think with that, just to conclude before I hand you back to Rory on non-discrimination, and this is one of the points we'll come back to. An open question is how other courts will react to this decision, and whether we will see the courts, for example, the US or China, taking more of an active role in global FRAND. I'll come on to discuss a couple of additional points, including some recent movements in China when we get to the discussion section. So with that, Rory, I'll hand over to you to deal with non-discrimination and the remaining issues.
Thank you. So the non-discrimination issue arose as part of the Unwired Planet Huawei litigation, and was centered around the fact that Unwired Planet had offered a license on more favorable terms than it was prepared to give to Huawei. And the question was whether the non-discriminatory limb of the FRAND undertaking, or the ETSI FRAND undertaking, required that it had to give that better license offer. This is what's known as the sort of consideration as to whether this non-discriminatory part is hard-edged or not. As you can see from the highlighted text here, the conclusion of the Supreme Court was that it's not hard-edged and that it's a general obligation. And there's some quite interesting points that came out from the consideration of this and how they got there. So starting with this and looking at the summary then on the next slide, it's this conclusion that the FRAND obligation is general and not hard-edged. And the consideration of the Supreme Court and the way they reasoned this is to say that FRAND is a unitary obligation, and so you have to consider it as that composite obligation, and you can't consider it as three separate distinct obligations which effectively act cumulatively. So you're not looking at it as there being an obligation for the contract to be fair, and if you've crossed that, you can then look at whether the contract's reasonable, and then whether you, once you've crossed that, you can then separately look at whether it's non-discriminatory. Having found that there was this composite obligation, they then make what in some ways can seem like a bit of a logical sort of counter leap by focusing specifically on the non-discriminatory element of it. But I think you have to look at this through the prism of what does non-discriminatory mean as part of its role within this, I guess, complex and composite unitary obligation. And so within that, they've been quite stark in what they've said. And the piece here they've effectively settled on is that as long as there's a single royalty which is available to all, the non-discriminatory element will be satisfied. I think one of the key qualifiers from this, though, that comes from the judgment is that this single royalty is something that has to be based on the market value of the portfolio itself. And so there has to be a rational basis or underpinning for why there is this single royalty rate that's been offered there. Within this, then, you find that there's this wider scope of what does it mean if better deals are offered elsewhere. And the court was quite clear on the fact that although you have potentially this single FRAND royalty rate that's available to all, that doesn't prevent the SEP holder from offering different deals or different license packages to different parties. However, if it does offer more favourable terms than its license rate, that in itself has no impact upon whether the card rate that's satisfying the non-discriminatory effort is actually FRAND or not. Part of the rationale and reasoning that they underpin this with was considering some of the background within the development of the ZTE obligation and looking at the fact that there had been this consideration of whether there should be some form of most favoured nations clause or most favoured contract terms clause tied to the giving of the ZTE undertaking. And it was expressly decided that there shouldn't be that obligation. And so the court has drawn from that the fact that you don't need to have this obligation being imported, as it was expressly decided not to be included. So that then leads on to the consideration of, well, what happens if there is differential pricing, and is there any way of dealing with this? And the court's view on this is that this becomes a matter of straight competition or antitrust law, and that if there is differential pricing, the way that that is dealt with isn't through the prism of whether it's FRAND or not, but whether it's creating any anti-competitive effects, which then cause competition law to bite. Moving on then to issue 4, and this sort of idea of competition law, which is coming through in looking at the Huawei and ZTE case law. And the first question was, did this prohibitory injunction or the application by Huawei did the application by Unwired Planet in this instance for an injunction in some way breach its obligations, and had it abused its position by so doing? Again, you can see that the Supreme Court found that it did not. And you can see from the highlighted text there the sort of main thrust of what the Supreme Court said. All of this is entirely consistent with the run of case law in the UK to date on this point, which is very much viewed that Huawei v ZTE isn't a mandatory set of procedures that have to be followed, but it more provides a guideline and set framework that people can operate around. The Supreme Court developed this then, and in finding that Unwired Planet hadn't behaved abusively, it considered the Huawei and ZTE framework and highlighted that there's only one mandatory condition from that case which needs to be considered or which needs to be complied with for there not to be abusive conduct. And that's the requirement that the SEP holder has to notify or consult with the alleged infringer before bringing any claim for an injunction. What this specific requirement is, though, is something that the court has left a lot of flexibility on, and again, I think inevitably will leave scope for debate and issues to be raised going forward, as it's highlighted that it will be very fact specific on the individual case in question as to what constitutes sufficient notification or consultation with the infringer. The court then moved on to consider the remaining steps within the Huawei and ZTE framework. And again, it came back to the view that's been coming from the earlier English case law that, again, this isn't a mandatory protocol that has to be followed. However, it's a framework that gives guidance to the SEP holder. And if this framework's followed, it provides a safe harbour, which means that there will be a finding against abuse of dominance. However, if a SEP holder doesn't comply with that framework, it won't necessarily be acting abusively. However, then it becomes, again, one of these situations that will be very fact specific and fact sensitive, and the court will have to examine the particular circumstances of that case to see whether or not the conduct is abusive. Part of the consideration as well on the obligations here was looking at the realities of the negotiation and dynamic that happens between the parties when a SEP holder asserts its portfolio and is making its initial offer, and then the counter offers that are being made by the implementer. And one of the things that was being argued was a consideration of if the offers themselves weren't being made, weren't whatever was the final FRAND rate determined by the court, did that in some way act as evidence or serve as evidence for non-FRAND behaviour on the part of the parties or one of the parties. Again, with this, you can see that the court concluded that it didn't. And again, this follows the case law and the decisions of the lower courts all the way through, which is this acceptance of the commercial realities of negotiations and the fact that parties can be behaving in a FRAND-compliant manner. However, they aren't necessarily having to make an offer that the court ultimately determines to be FRAND. The final point that I'd bring out on this then is looking at the piece here with, and it's a point that Steve brought up in his sections earlier, which is in looking at all of this, the Supreme Court was emphasising this whole purpose of what's going on in this FRAND process is ensuring a fair balance between the interests of the SEP owners and the implementers. And again, you see this consistent theme running through the judgment that the principal concern of the English court was the issue of holdout rather than hold up. And this is very much driven by the point on the first bullet on this slide, that the court takes the view that it will ultimately settle a licence that is on terms that are FRAND. And so hold up isn't as much of a concern because ultimately you will arrive at a FRAND licence. And so it's viewing that what can it do to prevent holdout. And again, it's this recurring theme of an injunction being a necessary component of the package and resources that the court has to ensure that there isn't holdout by the implementer. So considering then this issue of the injunction and looking at the view that the court took on that, turning to the final sort of issue before it as to whether damages would be an appropriate remedy in place of an injunction. And again, I think you can see that the court clearly decided that that wasn't the case and that injunction was a key element of the package that was required. And in fact, there was something particular that would be lost if an injunction wasn't granted. As I said, this wasn't particularly surprising because going through the theme of the court's view on what is of particular concern and issue, it's this recurring point that the court's concerned about holdout and what can be done to prevent that. Looking at that, then, it sees the injunction as the most effective, in fact, only tool it has at its disposal to try and ensure that implementers will be fairly negotiating with the SEP holders to try and reach this FRAND licence at the end of the day. Continuing from this theme then, as you can see, building on this concern of holdout was the concern that if there wasn't the underpinning or backbone of an injunction being able to be imposed, there was a real risk that implementers could hold out on a country by country basis just waiting until the last safe moment when they were compelled to pay damages in each country. I think you see this as part of the underpinning commercial rationale we've seen through this line of case law in the UK, where the English judges have very much been trying to find a pragmatic and commercial solution to what is effectively, and has been termed by some of our judges, the real issue or real dispute between the parties that are going on here. And it's this acceptance by the English judges, or the position they take, that in most situations it's likely that the licence that we settled by litigating parties or parties in dispute is one that's on a global basis. And so they're looking to try and do everything they can to prevent us being back to a scenario where litigation has to take place country by country, or even in a sort of broader scenario on maybe a select number of countries. One of the things that's interesting about this view and the decision that the courts took here is that it seems to reinforce the current line of case law and view in the English court that any damages that could be awarded if in lieu of an injunction, or if the injunction were taken by the implementer, are damages that are tied to the national rights in suit. And so damages can't be awarded on a global basis. And part of this distinction and discussion was seen, and we've got the paragraph reference there at 87 from the judgment, in the court was talking about the technical and procedural differences between how an assessment would be made as to the award of damages following infringement in an English patent action compared to the royalties that would necessarily be paid under the contractual licence. And so very much this decision is sort of underpinned that the current line of case law, that any damages that can be awarded by the English court will be tied to the national right and that scope. The final thing that sort of flows from this is that although the court was keen to emphasise that the injunction itself is an important part of its toolbox for dealing with these issues, it still remains appropriate for the implementer to have the right to choose whether it's going to follow the precedent we've set in TQ Delta as to whether it will take the licence that's been settled on FRAND terms or accept the injunction, locking it out from the UK market. I think then this is a convenient point to move on to the discussion and where things go from this decision. And the starting point from this, and it's something that people will be familiar with from lots of the press reporting, is that generally this is viewed as a significant victory for SEP holders. And I think it's safe to say that this is a generally held view across many of the legal markets. The reason this view is taken is that effectively the English court has said that it is competent and willing to determine global FRAND licenses, irrespective of whether all of the parties are consenting to the English court's jurisdiction. The fact is now that predominantly, as we've seen to date, it's been the SEP holders that have chosen the English court, but there is now a forum where it will determine the global FRAND license, irrespective of whether the parties want to be there. We then also see that the court has reinforced that the flip side of it, accepting this jurisdiction and how it will underpin this, is that for any party that is drawn into the court's jurisdiction, if that party doesn't accept the licence that's ultimately to be determined by the English court, the consequence is likely to be an injunction locking it out of the UK market. And again, for certain undertakings, this is probably going to be quite a significant threat to have there, as the reality of withdrawing from the UK market, as some handset manufacturers have already done, is probably not a viable option for everyone. If I were looking to this actually spark off the discussion and draw on these themes, we'd say that actually the decision itself has left quite a lot open, and there's still quite a lot to play for. I'm going to pick up on three particular themes for this. The first one is this question of jurisdiction, and where is the appropriate jurisdiction for deciding the FRAND dispute between a SEP holder and the implementer. Although the UK court has said it has jurisdiction to do this, it's been explicit in not shutting out the fact that other courts also may well have this jurisdiction, in particular because of the way it's based its jurisdiction to do this on the contractual interpretation of the ZTE obligations. The second area we'd like to talk about is how should the FRAND decisions of foreign courts be accounted for? And again, the Supreme Court's accepted the developing and developed line of English case law that it's appropriate in settling any FRAND licence that decisions of courts of competent jurisdiction covering patents within that portfolio or particular jurisdiction of significance should be accounted for. However, this is still a developing area, and there haven't been any firm judicial dicta on how this should take place. The final area that we'll talk about is enforcing the equity contractual obligation itself. And there's a number of areas where the Supreme Court has left this open for potential development of the law as to how this obligation can and should be enforced. And with that, I'll hand back to Steve.
Thanks, Rory. I'm quite conscious of the time as well, so we'll try and make sure that we don't overrun. And a couple of questions have come in as well, which I'll make sure that I answer. So on the jurisdiction point that Rory has been mentioned, I think that there's two key points really. The first is one I mentioned earlier, is how are other jurisdictions going to react? And I mentioned some movement in China. There has been a recent decision of the Chinese Supreme Court in the Huawei and Conversant litigation, where the Chinese Supreme Court granted an anti-suit injunction which prevented Conversant from enforcing an injunction it got against Huawei in Germany. Now that obviously the reasoning of the Supreme Court in that case was relatively detailed, but ultimately what it came down to is that there were overlapping patents in those two pieces of litigation, and the Chinese court felt that if a rate was determined for those patents in Germany, then it could also impact on the Chinese decision. And Huawei said, well, look, if we are injuncted in Germany, we will have two choices. Either we will have to exit Germany, or we will end up having to settle at a rate which is higher than the rate that was determined in Nanjing. So it was interesting to see the Chinese court issuing an anti-suit injunction in that case, preventing Huawei from being injuncted in Germany. And there's also been another recent decision, this time from the Wuhan court, in which an anti-suit injunction has been granted against a SEP holder in another foreign jurisdiction. And that one hasn't been as widely publicized, but if anybody wants more information on it, then I'm happy for them to reach out and contact me about it. And a couple of questions that have come in. One is, what are Huawei's options now? Must they leave the UK market, given that they won't want to take a global license, and will they leave? Ultimately, that is the choice that is there for Huawei. Do they take the injunction or do they take the license? I mean, it remains to be seen whether they'll leave the UK market. Obviously, the UK is a very small percentage of Huawei's market, but I don't think from a business perspective that, from Huawei's perspective, from a business angle, they'll have to work out whether or not it makes sense for them to continue in the UK or not. There's obviously huge political issues going on with Huawei in the UK at the moment as well in terms of 5G. So I think it'll be interesting to see what Huawei do about that. Another question that came in related to validity. Rory, if you could move to the next slide. And the question was, effectively, given that there is a problem with over-declaration, which nearly everybody on the line will be familiar with, isn't it better to have the invalidity actions first before working out the FRAND aspects? So from a UK perspective, you have to have a finding of a single valid and infringed SEP in order to get through your gateway to global FRAND. But one point that I wanted to note is in the second bullet point there, in the Conversant litigation in the UK, Huawei has in principle obtained permission to adduce evidence on validity in the FRAND case in the UK. It's the first time that we saw that kind of application and that it was allowed. It remains to be seen exactly how that will be dealt with and how it pans out. But in principle, Huawei has taken that line whereby they've said, look, validity must be taken into account here and must be taken into account by virtue of the global FRAND exercise. But they're not suggesting, for example, that there needs to be 5 to 10 technical trials in order to do it. They're attempting to build it into the wider global FRAND assessment. But more broadly, this idea of accounting for foreign decisions, I think this will be one of the more interesting areas to see what the UK court will do. Because one thing they haven't done is said that they will do global France the exclusion of all other jurisdictions. I think when you read the judgment, it's relatively clear that they are open to foreign courts deciding, for example, the rates that might be applicable to the US or to China, or to whichever jurisdiction they are being asked to look at on a national, at least a national level. But ultimately, one of the other things that springs to mind, of course, is will this case from the UK Supreme Court lead to a forum race and the kind of anti-suit injunctions that I've mentioned already? I think the question to that inevitably is yes. I think it is likely to lead to forum races, particularly as time passes and jurisprudence in different jurisdictions becomes more developed, and that's almost inevitable. And actually, at the moment in the TCL and Philips litigation, there is effectively a running dispute between the UK and the French courts in relation to which of those courts is going to be the court to determine the global fund rate and global fund exercise in that case. So we're already sort of seeing cases where there is this sort of dispute between parallel forums going on in these global fund cases. So we can move on to the next slide, Rory. So in terms of the ETSI obligation, I don't want to spend too much time on this. We've talked about it quite a lot in any event, but I think it will be interesting, this is the third bullet point, and to see how the English case law develops in relation to this distinction that was drawn in the Supreme Court judgment between the ETSI contractual right and damages that are owing for infringement of a national patent right, and Rory's already mentioned this. The only case that we have today that at least was decided is the TQ Delta case that I mentioned earlier. There had been arguments that were raised by Philips in litigation against, for example, HTC and ASUS, where there was a suggestion made that damages for past infringement in the UK should in fact be global fund damages, but that point was never decided, and it will be interesting to see how far that line will be able to run following the Supreme Court decision, where they made a very clear distinction between damages and royalties. I think the key aspect of that is that Rory mentioned earlier that the Supreme Court said that damages was not an adequate remedy in lieu of an injunction. And it's very clear from that aspect of the judgment that when they were looking at damages, they considered it to be national damages on the basis that we're saying, look, we can't have this country by country situation where no injunction is available and the implementer has to go to each country to get its damages award before it gets paid. So it seemed to be implicit within that section of the judgment that they considered that damages would be limited to the national jurisdiction in question. So it'll be interesting to see if at all, how far that sort of line that was being developed by Philips in its litigation can go. And of course, the sort of overarching question, which I know was discussed at length at the Oxford conference in February this year, as to whether or not there is some kind of mechanism, some kind of independent body, be it ETSI in association with ETSI, a completely independent body, or WIPO, whomever, that might develop some kind of dispute resolution mechanism for these global fund cases that can be developed by the industry for the industry. So it'll be interesting to see, following the UK's decision to effectively adopt that mantle voluntarily, whether or not there'll be now a sort of more appetite for there to be a different independent tribunal that effectively is being developed in consultation with the industry. So I think with that, I think we've come to the end of the points that we wanted to discuss. There've been a number of questions that have come in. I think I've answered most of them. One of the questions was, is the UK Supreme Court being too high-handed? which is an answer, I think, which depends on whether you're a step holder or whether you're an implementer. But I've obviously heard very fierce, heartened debate on both sides of the divide there. I mean, on the one hand, you have people saying, well, it isn't too high-handed because it's it's a jurisdiction which is stepping in and preventing periods of holdout over a period of many years, which has been very difficult. But by comparison, obviously you have implementers who look at the situation and have very small markets in the UK, and feel that it's not fair on them to be pulled into a jurisdiction with such a small market against their will, and for that market to, for example, have a decision on what rates they should pay in some of their other very important major markets elsewhere in the world. So I think it really depends on which side of the debate you sit on as to the answer to that particular question. And I think we'll ultimately see, in addition, the reactions of the other courts. It's actually mentioned in the Supreme Court judgment that the Chinese court was critical in the Conversant litigation of the fact that Conversant effectively hadn't tried to get the Chinese rates determined in China. So I think it will be interesting to see how that develops.